back the Ad Hoc Committee to initiate legislation to amend Section 25 of the Constitution, which deals with land expropriation without compensation, has resolved to re-advertise the 18th Constitutional Amendment Bill for public comment. This after it made several amendments to the initial bill that was subjected to extensive public participation. For more on this, we're joined by the Chairperson of the committee, Ad Hoc Mathole Motshekga. Thank you very much for your time here on eNCA. So what does this mean now, taking the argument for Section 25 of the Constitution back to the public?
The situation is that when we started the process, there was a compromise on the text of the bill that was taken to the public. And political parties had not made input into what should come into the bill. And after public hearings, some submitters requested that we give them an opportunity to make further submissions, which we did. But when the debate ensued in the Ad Hoc Committee, some members said that we were exceeding our mandate because we were dealing with subsections which were not referred to in the original text.
So we've discussed the Section 25 of the Constitution for quite some time now. It's been a very robust debate, even amongst politicians in Parliament. Are we really going to realize Section 25 of the Constitution in South Africa? All right, it seems we've lost Ad Hoc Mathole Motshekga. Can you hear me, sir?
I hear you quite well.
So my question was whether or not we actually will see Section 25 of the Constitution realized in South Africa. Many believe we won't.
No, I don't think that question is fair, because we are still in the process of engaging on the issues where parties still hold different opinions. And we have no doubt that through the inputs that will come out of the new bill that has been published, parties will be able to find one another and reach consensus on the amendment. So it would be premature to say that we will not succeed whilst we are working towards that success.
And what are some of the submissions, for instance, that you talk about that are differing from what already is in Section 25 of the Constitution?
You know, there's a proposal, for instance, on state custodianship, which means that all land, water rights and everything should be placed in the hands of the state. And that is also interpreted as nationalization. And we are saying that our mandate was not to write a new Section 25. Our mandate is to make explicit what is implied in Section 25. And therefore, there are differences of opinion on that state custodianship. The second one is the question of the cut-off date of June 1913, because the argument is that land was not taken away from African people in 1913. The process of land disposition goes back to the 17th century, that in 1913 it was a legalization and consolidation of the land that had been taken away. And that therefore, if you use the cut-off date, it would mean that African people can only claim land within the 13% that was allocated by the 1913 Act, read with the 1936 Act.
And Dr. Motshekga, while we talk about the Constitution and this important section of it, there is also something happening in South Africa that is testing the same Constitution, mostly by people who fought for the liberation of this country. I'm just wondering, as one of those people who were, in the trenches fighting for the freedom and liberation of the people of South Africa, what you think of what's currently happening in South Africa.
I didn't hear you.
I was saying that, Motshekga, as we're talking about the Constitution, there is currently, something happening with people testing our Constitution in South Africa. I'm referring to the Constitutional Court's judgment against the former President Jacob Zuma, as well as the fact that he has now been taken to prison to serve a 15-month jail term. And I wanted to know from you, as a person who is among those who drafted or who was there when the Constitution was drafted, what you think about what is currently happening with the challenges against our legal system, our lawmakers, as well as the Constitution itself.
I think that we should leave that to the processes in the court. You will know that on the 12th, that matter will be heard before the Constitutional Court. I do not want to preempt what will come out there. I would prefer to leave that matter to be settled within the court and rest the matter at that.
All right, we can leave that matter out, Dr. Motshekga, but in terms of our legal system in South Africa being attacked, would you not have any reaction to that? Our Constitutional Court and the legal fraternity as a whole being accused of bias, for instance. This has to trickle down to even the most basic of people who are not politicians, perhaps. But basically, I just wanted to ask you, if we take the former president out of it and we look at our Constitution and the legal system being accused of such, of such acts, what's your reaction to that?
The good thing is that our courts operate in a way that is transparent, and the judgments are televised, and all the arguments are televised, and therefore, if anybody wants to attack that, they have to advance evidence to that effect. But to the best of my knowledge, I think that the courts are functioning according to the Constitution and the law. So I have not had anything that is convincing me that the courts are biased.